Hi, this is Congressman Thomas Massie. We're about 48 hours from the deadline for the Attorney General to produce all of the Epstein files according to the Epstein Files Transparency Act, which was signed on November 19th. So that makes the production of these materials in a publicly searchable format due on December 19th. And I wanted to talk about some of the things to look for and what we may be anticipating and some of the unique aspects of this project. Let's start out with, how will you know if they've released all the materials? Well, one of the ways we'll know is there are people who have covered this case for years, and I've talked to them in private, and they know what some of the material is that's back there. But the other way that we're going to know is the victims' lawyers have been in contact with me, and collectively they know there are at least 20 names of men who are accused of sex crimes in the possession of the FBI. These would reside in the FD 302 forms. The FBI fills out these forms to summarize or memorialize what a witness gave them as far as testimony when they interviewed with the FBI. So if we get a large production on December 19th and it does not contain a single name of any male who's accused of a sex crime or sex trafficking or rape or any of these things, then we know they haven't produced all the documents. It's that simple. So that's a good thing that we will know. One of the really novel things about the way we went about this, as opposed to my other experiences on the Oversight Committee or the Judiciary Committee, is that this is a law. It's not a subpoena. So what we've seen in the past is that Congress issues a subpoena to the executive branch, and the executive branch ties up in court and tries to delay and obfuscate, and they know that if they drag it to the end of Congress, that congressional subpoena expires at the end of Congress. And so the next Congress they would have to issue another subpoena. But what often happens is the majority changes, or the person in the White House is no longer there, or the person in that office is no longer there. And so there can't be any prosecution or criminal or anything like that carries on past the Congress. This is very different. This is a law. There's no expiration date on this law. So let's say you have an attorney general who is not in compliance with this law. By the way, the law specifies the attorney general's office, not Attorney General Bondi specifically, but anybody who is in that office holding that seat. So if she were to leave, and let's say she's in non-compliance and has broken the law, then whoever gets in that seat is automatically obligated that day to release the files, because it's directing the Office of the Attorney General to produce files from 3 different locations, by the way. The U.S. attorneys have material, the FBI has material, and the DOJ has material. Now, the DOJ will also have material, thankfully, from the grand jury investigations and trials. So but the interesting thing that I want to point out here is, let's say they try the old tactic of running the clock out until the end of this Congress, which is about a year from now. That won't work, because what can happen is a new attorney general can bring charges against a former attorney general. And so what you might see is that an attorney general under Trump, if they refuse to produce these documents in compliance with the law, which would be ironic because the Attorney General is the chief law enforcement officer of the land, but if they refuse to produce these materials, then let's say whoever is the next president, their Attorney General could bring charges, because the statute of limitations will not have run out on noncompliance with this law. It's unique. It's different than if there were a subpoena and Congress had referred the person in noncompliance with the subpoena for contempt and who do they refer it to? To the DOJ. And so that's why you can never get to the bottom of these cases when it's just a subpoena. But this is a law, and it will last for forever. The other interesting thing here in this case is we're already seeing progress as a result of this, the Epstein Files Transparency Act becoming Public Law 119-38. There were 3 courts of interest that had grand jury material, one in the Southern District of Florida, a judge there, and then 2 judges in the Southern District of New York. These are federal courts. They had previously said, because of Rule 6E of the criminal proceedings, that they could not give the grand jury material to the DOJ. Interestingly, after the Epstein Files Transparency Act passed, the DOJ did go back to these judges, and I'm going to assume it was sincere. Maybe it was an attempt to get them to say no, and in the hopes they would say no, but I'm going to assume they were sincere in their request from these judges. And what they did is they requested that the judges produce the grand jury material a second time. And in all 3 cases, in all 3 of those courtrooms, the judge said, yes, the Epstein Files Transparency Act, because it's a new law, it overrides the pre-existing general laws. So that's good. We've already seen movement. And another interesting thing we saw in those judges' rulings is that they said that they will redact, in accordance with the Epstein Files Transparency Act, information that would identify the victims. If you remember, in the 5 months of siege warfare we had trying to get this legislation through the House with Mike Johnson opposing us, he would repeatedly say that the release of this material would endanger victims. In fact, in the week before we passed it, he was still repeating that line. We had to keep pointing him back to the law and show him the chapter and verse where it says, no, redact the victims' names and identifying information. So we've seen movement from the grand juries. That is good news. Finally, there's an interesting aspect of this, in that Pam Bondi has said in her official capacity, but not necessarily under oath. By the way, if you say something to a TV camera in an interview and you lie, in Washington, D.C., that's okay. You can't be prosecuted for that. So we had her saying that there was tons of material on her desk and that she was in possession of it. And then she eventually changed her story to say that there's no material. The only thing that really exists anymore is child sexual abuse material, pornography, and that she wasn't going to release any of that. Well, we know that's not true. We know that she has more material and she's going to have to produce that material. So that puts her in an interesting position. In order to comply with the law, she's going to have to prove or give proof, evidence that shows she wasn't forthcoming in her previous statements. Although that wouldn't necessarily be illegal. Again, in Washington, D.C., you're allowed to spin, and lie, and we've seen them do it before. But there's a situation where it is illegal to lie, and that is when you come before Congress and give testimony. I'm sure you've all seen them. They raise their right hand and they swear that they are going to give the truth to the best of their ability, so help them God. And so we had Kash Patel do that in front of the Senate when he testified, and he said that there's no evidence in his possession that would implicate anybody else other than Jeffrey Epstein. So when he testified in front of the House Committee on the Judiciary, on which I sit, I asked him that question again. I said, you've testified in front of the Senate that there's no information that exists that would implicate other men. I said, what about the 302 forms? He said that his staff, I said, have you reviewed those personally? And he said that his staff had and that he trusted them. This sets up an interesting situation, because when they produce these materials, what we're going to find out is they are in possession of evidence that other men may have been guilty. And it's going to be credible evidence, because they're going to be, I believe, multiple corroborating witnesses, i.e. the victims, who've given statements. and those are in the possession of the FBI. Again, we'll know if they're giving us all those documents if they produce documents that have names of men on them. So let's see what happens Friday. Interestingly, Congress is adjourning a day early so that we won't be in session on Friday when these documents are required to be released, again, in a public searchable format. And so it'll be Saturday, really, before we know. Representative Ro Khanna, who is my co-sponsor and the individual on the Democrat side of the aisle who co-led this effort with me the entire way, he and I will be on Face the Nation Sunday to talk about what we've learned and what they've produced. But again, this is a very unique situation. A lot of times, when you're talking about did the executive branch comply with the request from Congress, or are they in compliance with the law, you're trying to parse out the meaning of words like emoluments, or you're trying to interpret laws that were passed in the antebellum era, in the Civil War, right after the Civil War, when we talked about the electors and the role of Congress in certifying electors. But this is a case where the president who appointed the Attorney General and for whom the Attorney General works has signed a law, and the ink is not even dry yet on his signature on this law. There's nothing that's subject to interpretation. We're not arguing whether this law is valid. We're not arguing the case history of this law is interpreted by the Supreme Court. This is a fresh law that was passed unanimously in the Senate, passed 427-1 in the House, with modern terms that are not ambiguous, that federal judges have already demonstrated that they understand and that they are going to comply with. And this president, he's agreed to comply with this law if he signed this law. He had a part in making this the law, so his Attorney General has to comply with it. And there are penalties if she does not. And I don't want to get into that. We may talk about that on Sunday shows. I'm hopeful that there'll be a large document production on Friday. One other last thing, some people have said, oh, what about the ongoing investigations? Because if you remember, Attorney General Bondi had closed all the investigations. There were no federal investigations. But on the eve of the passage of our bill, she announced, and the president also put on social media, that they were opening new investigations. Now, his had a partisan bent to it, but in the wake of that, my colleagues and I, this is a bicameral, bipartisan letter that we sent to the Attorney General, and we've asked for a sit-down with her, or even her staff, to explain to us what is the new material that they found that warranted opening new investigations. Because I know some of you are concerned that they're going to try to use this claim that releasing this material would impede an ongoing investigation. The problem with that claim is we've already said in our law, in the letter of our law, that it would have to be material that would affect that particular investigation specifically. And the redaction can only be temporary, for instance. That's also in the law. So they can't open enough investigations to cover up the terabytes of information that they are in possession of and that we hope to see on Friday. So I'll keep you posted. I'll come back on. We'll talk about what we found and to what degree the Attorney General is in compliance with the law. But I'm hopeful. Thank you and God bless.